Jennifer Gundlach. I am a Associate Dean for Experiential Education at Hofstra Law School, and my colleague Andy Shepard and I should have put his name on this too because we've done this as a joint project with a couple of other folks at our school as well. And basically, this all came about from an early conversation that we had. How many people remember the Erie Doctrine from civil procedure? Civil procedure professors, put your hands down. You may feel, as we did, that that was one of the most troubling doctrines that students didn't understand. And so it all started with how can we actually get them to understand this, because we'd tear our hair out every time we were reading final exams. So that was the beginning of it. But there were also a lot of other questions that we had. So how might we, in our first year courses, expand students' thinking about appropriate learning outcomes and our own thinking about learning outcomes for what we could be doing in those courses? How might law professors work more collaboratively with each other? We began to feel like we really wanted to go across not only within people who are teaching the same courses, but also across disciplines into other classes as well. So we came up with this case file, Sachs v. JIT, which is Jefferson Institute of Technology, which is a fake case. And we use it in our civil procedure courses, although we've also expanded into legal writing, into contracts, and some upper-level courses as well. And the idea is that we've created a simulated case file where students can engage in a number of simulated exercises. The point being that this isn't designed to, which I've been really staunchly advocating against, this isn't designed to teach skills in civil procedure. It's actually designed to teach more applied learning of what they're learning in civil procedure. So that's the big ticket. But also understanding the development of a case for contextual learners, learning how a case develops from the, just interviewing a client, and so on and so on. So we have a lot of tools that we've started to use. We obviously developed this case file that is being published by Wolters Kluwer, we hope, in the spring semester for your use if you are interested. We also are working on an online learning platform which basically simulates a case management system. For those of you who are clinical professors and are using case management systems in your clinics, it's simulating that type of experience with the case file. So they can download files, they can download forms, we can do the video assignments and that kind of thing in the case file. I give you an example of one type of exercise that we do. So how many people struggle with students not really understanding the role of facts in their classes, right? So fact investigation is something that we've historically not done a great job with. So we have a fact investigation that is really the first assignment. Before a case is filed, all they do is get a really introductory memo that tells them a little bit about a client who has come in, and they have to engage in some fact investigation. But interestingly enough, it's not about the facts of a case and learning about, all the specifics. It's really more designed to focus on jurisdictional facts. Because what we've covered up to that point in time is personal jurisdiction, venue, forum nonconvenience, subject matter jurisdiction, and the Erie Doctrine. So it's designed to dig deeper into them applying those doctrines that they've been learning. So, what facts will we need in order to reach a more definitive conclusion about the following issues? Where are you going to commence an action? Can we commence it in federal court? Should we do it in state court? Where can we establish personal jurisdiction over JIT, the defendant, and so on and so on? So getting them to think about, as a plaintiff's lawyer, if they're representing the plaintiff, what do we need to be thinking about when filing a case? So all these doctrinal issues that they're learning have a purpose. Every plaintiff's lawyer is going to have to think about where they're filing the case. For the defendant's side, what they're learning about is some basic facts. Again, they know that this student has died on their campus, but they don't really know a lot more than that, but they're assuming that the plaintiff is going to file a lawsuit. And so they need to also, from the defendant's side, begin to think about where can we anticipate that the defendant is going to, or that the plaintiff is going to file the lawsuit, and then what options do we have? Can we defeat an effort to commence an action on the basis that there's not personal jurisdiction? Can we, if they're filing in federal court, might there be a lack of subject matter jurisdiction? So thinking about diversity issues and whatnot. Are there potential motions for transfer or for forum nonconvenience that we might determine as well? Again, thinking like what a defense lawyer is going to need to anticipate. Even before the case is filed, a good defense lawyer is beginning to think about those things. So, what's the relationship to learning objectives? Understanding the difference between law and facts, that's a big one. Identifying facts, relevant legal theories, sources for finding facts, indicating sources for finding facts. A lot of times a piece of their fact investigation plan is they have to identify where are they going to get the fact. And a lot of them will say, oh, I'm going to seek a deposition of the defendant. And I'll say, the case isn't filed yet. Try again. So what sources do you have available to you? So we'll start thinking about where you find facts. What facts are attached to whatever the elements are of the legal doctrine that they're learning. So, results after years of using this, we've probably used this for what, Andy, 4 years now maybe? Much better synthesis of law and facts, much better demonstration of these doctrinal principles in their exams, demystifying the concept of civil procedure. Everybody always says it's the hardest course in the first year. They seem to really get the context of it now. And I've given you some excerpts from student evaluations. They love it. And I think I'm preaching to the choir here that everybody knows that students actually learn a lot better when they're given that context and that opportunity to apply what they're learning in the classroom and what they're talking about, what's being lectured upon when they're reading in their cases, and they get to actually get their hands a little dirty. So those were my excerpts, and I'm done.